For the Quatrini Law Group, with offices in Uniontown and Somerset as well as Greensburg, specializing in personal injury, workers' compensation, Social Security disability, long-term disability, and veterans benefits. You can call them at 888-534-6016. Again, 888-534-6016. And today's program has been recorded for playback at this time.
Good morning. My name's Dave DeRose. I'm an attorney with Quatrini Law Group. We have offices in Altoona and Pittsburgh. Our main office is in Greensburg. We are a personal injury firm, a disability firm. We do a great deal of work in the workers' compensation area, representing injured workers. We do auto accident cases and other types of injuries that people sustain. And we do a lot of Social Security disability work. We also do some long-term disability work. Our firm now has 16 attorneys. I'm primarily doing estate planning and estate administration when someone passes away. I have been an attorney since 1976, so you can kind of see I've been around a while, and my practice is really limited pretty much to the estate area. We do have another attorney in-house here in Greensburg, James Horchak. He's also an accountant, and he does help with the estate-related matters. Today, I wanted to focus on estate planning primarily. There may be some other things we can talk about, but the estate planning process, and people, all of us accept the fact that at some point we're going to die, and it would be wonderful if we'd have a will that would dictate what happens at death. So if you pass away, to protect your family, you want to have a will. The other subject we don't like to talk about is any of us becoming incapacitated. Incapacitated to the point where, well, we really can't do for ourselves. We can't sign a check. We can't sign an agreement. We can't make good decisions. So somebody else has to step up for us. And you step up for somebody through use of either a financial or a medical power of attorney. So in my opinion, it's not limited to age. This is same for people in their 20s as it would be in their 60s and 70s. Everyone should have at least 3 documents. And there's a fourth, but the main 3 are a last will and testament, deals with what happens at death, and then a durable financial power of attorney and a durable health care power of attorney. A last will and testament is a written document. It lists in it how you wish your assets at your death to be distributed. And it only takes effect at the time of your death. It isn't a document you use to direct your medical care or your financial matters during your lifetime. No, it's a document that takes effect at death. What does a will do? Well, a will enables you to identify your beneficiaries. And that might be, a husband identifies wife and children or grandchildren. Wife identifies husband and children and grandchildren. Maybe there are other loved ones that you would wish to leave something to, a sum of money or something very specific. Maybe you want to acknowledge a close friend, or maybe you want to make a charitable gift to your church or to the Cancer Society. or to an organization you've been affiliated with. You can specify dollar amounts in your will, and sometimes that's not the best idea, but dollar amounts to go to a church or an organization, yeah, that makes sense. Specifying dollar amounts for a child, may not. Usually we do percentages that if there are 3 children, we might say they equally inherit. Or there's one child that has done some things for us where we're going to give that child, 40%, and we're going to give the other two 30% each. It is extremely important in a will if you have minor children, children who have not attained the age of 18, you want to appoint a guardian. If something happens to you or your spouse together, who takes care of your kids? Who is the physical person in charge of their care? And that should be something you designate. This shouldn't be something just left to, somebody in the family will step up. That may not be the person you'd like to have step up for that purpose. So you should appoint a guardian. Also, for children who have not reached 18, you should also create a trust within your will that basically says, I want to take the money that would go to my child who's now 10, 8, 12, and I want to appoint a trustee, maybe my bank or financial institution whom I trust. And they'll hold that money until the child hits an age. 18 is the age of majority, but many of us don't think that children are able to maybe handle, especially large sums of money at 18. So trusts sometimes go to age 25 or 28, whatever you're comfortable with. The other thing about a will is that you want to appoint an executor. You want somebody in your connection of people who will administer your affairs at your death. Who's going to take charge? And, in a husband and wife situation, usually husband passes, wife's in charge. But what if wife then dies quickly? People, one right after the other, or they die almost simultaneously. We have to have somebody we're appointing as executor or personal representative that can step in and gather the assets, identify everything, start to pay bills. There's a house, there's going to be house bills to pay, maybe some medical bills, maybe a Visa card, maybe a car loan. Whatever it is, that executor has a big job. And they need to begin, as quickly as possible. But we want somebody who's extremely capable. That may be one of our children. It may be a brother or sister. Sometimes in certain situations, it's even a bank. We actually appoint a bank to take over at our deaths. If we have a disabled child, that's sort of another issue. You really want to think about that and decide, okay, I have a disabled child. That child resides with me. There might be Social Security benefits and Medicare benefits that child can avail themselves of if they haven't already. But you might want to then use a special needs trust to supplement any government benefits for the remainder of the child's life. Special needs trusts are specialized documents that you really need to see your attorney, and you need to have someone prepare that so that it qualifies and it does not interfere with any benefits the child is already receiving. People always ask, how do I, if I have a will, how do I change it? Well, first thing I would say is, please, consult an attorney. Please go to an attorney. do not make handwritten changes to your will. People pull out a will, they start to scratch things out, write things in. That's one of the worst things you can do. You can destroy your will. You can tear it up. You can burn it. You can shred it, and you'll have no will. But go to an attorney if you want changes made to your will, and please be very careful. This sounds self-serving because this is our business, but using forms you get from the internet that you've picked up from some Office Max type place. That can be very dangerous. Somebody needs to evaluate your situation and make documents that are specific to it. People always say, too, okay, as I'm thinking about and preparing my will, just tell me a little bit about the people I'm leaving behind who are going to inherit what I have. What do they have to pay? What's the inheritance tax in Pennsylvania? An inheritance tax is assessed on the value of your estate. So we look at, yes, you have a house, a car, a bank account, maybe you have some stocks and bonds, and we add all that up. And we say, okay, at the time of death, this individual had $300,000 of houses, cars, and money. But in the estate itself, we've paid some income tax. We paid a Visa bill. Oh, we paid off a car loan, paid off a small mortgage. We had a funeral bill, and on goes the list. So from that $300,000 that you say, well, that's the value of the estate, we've spent maybe $50,000 out of it on expenses, on costs, on fees, debts. So the inheritance tax is assessed on the net value of the estate. If my estate is passing to my children, children and grandchildren are 4.5%. So on $250,000, the estate would pay on their behalf 4.5% of that sum as inheritance tax. Now, if I leave my $250,000 to my brother, that's a 12% rate. And if I leave it to my neighbor or my friend, that's a 15% rate. Please also note that between husband and wife, there is no inheritance tax. So if a husband dies and the husband owns a piece of property or owns vehicles or something of that nature, there is no inheritance tax that the spouse will pay to inherit that property, etc. That's tax free. So that's kind of a quick summary on wills. And again, that I believe everybody should have one, no matter how small or large your estate is. Just as equally important, though, you've got to think about the possibility you could become disabled. You know, it's not something that anybody likes to think about, and as we age, it's a distinct possibility. The best thing you can do is create a financial, we call it durable financial power of attorney, durable medical power of attorney. These documents enable you to pick the individual or individuals whom you'd wish to step into your shoes, to make decisions when you can't. A durable financial power of attorney enables you to appoint a trusted individual who will have authority to sign your name in your absence or in the event of your incapacity. You know, sometimes people may be traveling and they need somebody to sign something. Fine, they have a power of attorney to do that. But most of these things are used at times when you're sickly and you can't do for yourself. This document is all about financial matters, and this document is a good document until the day you die. The day you die, it terminates. And usually we do a separate document for financial purposes, separate document for medical purposes. The key to these documents, and right now I'm focusing on financial, you want to appoint a very trusted individual. Now, in a husband and wife situation, that might be your spouse. You may have 3 or 4 children, and one of them is somebody you say has absolutely vast knowledge of financial matters, very trustworthy, able to handle things if something happened to you. Fine, that may be your pick, but it also may be that you don't have a spouse or you don't have children. So maybe you've got a brother that or a sister whom you trust, or you've got maybe an accountant that you're a good friend with, or a neighbor. But whoever you appoint has to be somebody you are very, very comfortable with stepping into your shoes, because at that point, if I'm incapacitated and can't do for myself, that individual I've appointed may be the individual who has to decide, well, you know what? He's not coming back to his house. I've got to get his house in shape to sell. I'm going to clean out his house. I'm going to hire a realtor. I'm going to sell his house. He's not going to use his car. I'm going to transfer his car. He's got several bank accounts. He has an IRA account. He has a pension fund. Okay, where's the best place I take money from to pay for his care? So he or she in this case, might be conferring with a financial advisor, maybe a CPA. That individual is really you. That individual is stepping into your shoes and operating for you in your best interests. So the durable financial power of attorney, again, has to be in writing. There's a format in Pennsylvania that needs to be followed. We witness that document. We notarize that document for reasons. The healthcare power of attorney is a document, again, we're appointing somebody step into our shoes to make healthcare decisions. Now, a healthcare power, right in the text of the document says, okay, I've appointed somebody to act for me, but they are not going to act until my treating physician, my medical people, indicate that I am no longer able to understand and communicate decisions. I'm not able to do that. So someone else has to do it for me. And usually the healthcare power of attorney enables an individual, could be a son, daughter, again, brother, sister, aunt, uncle, someone to step in who knows you well and says, you know what, I'm going to make a decision about where he or she's being treated. Maybe you're in a hospital and the individual thinks, you know what, we're going to move them out of that hospital and we're going to move them to Cleveland Clinic. They have a specialist there. That's what I want. We're going to decide with the doctors about surgery, about procedures, etc. So this is a very important role. And again, if you are incapacitated to the point where you can't make decisions, you have to appoint someone whom you trust implicitly. The other part of a durable healthcare power of attorney is what we commonly call a living will. Don't confuse that term with the term living trust. Two different things. A living will is simply usually a portion of a healthcare power, or it could be a separate document, that is an expression of your healthcare treatment needs when you can't do for yourself and you are in what we call an end-stage medical condition, meaning you're going downhill. You are either permanently unconscious, you are in a vegetative state, you are terminal. So you have the right to say in a living will, you know what, I've thought about being in this irreversible state, this loss of consciousness, have no capacity to interact, etc. And if that happened to me, I want my agent to know, and I want the world to know, that I do not want extraordinary means taken to simply prolong my life. That's not something I want to happen. So in your healthcare power of attorney, you give your agent, this person you've appointed, access to your medical and hospital records. They've got all that. They've got the ability to communicate with all your healthcare providers. And they've got your instruction about, do I want a ventilator to be placed on me if I'm dying? Would I want dialysis? Would I want surgery? Would I want chemotherapy? Would I want to be revived, CPR? You've told them that. And then, of course, there's some decisions that need to be made. But you've given them sort of a roadmap. And that's what's nice about this. There's nothing perfect about this process, but at least you've given somebody an idea of what you're thinking while you're able to think. If you don't have a healthcare power of attorney, you don't have one at all, the law says a spouse can make decisions for you, and if there's no spouse, your adult children could make decisions for you. If there are no children, then if your parent was alive, the parent could make it, and then we get down to brothers and sisters after that. But my suggestion is, again, you have a will, you have a durable financial power of attorney, you have a durable healthcare power of attorney. Those are the three important documents. You also have to realize, if you haven't prepared, you don't have powers of attorney. You don't have either one of them. And now you're sickly. You're in an accident. You can't do for yourself. Maybe you don't have a spouse and you have kids that are scattered. Somebody has to step up and help you. Well, you haven't prepared for that. So someone, hopefully in your family connection then, has to file a guardianship proceeding with the court. That can be avoided by having a power of attorney. Nothing wrong with doing a guardianship proceeding, but understand it takes a little time, and somebody's going to spend some money. And there's going to be a doctor involved, and a doctor's report, and a doctor testifying. So it's not, it's really not something you want to leave to chance. Now, I mentioned before the term living trust. Many people say, how about a living trust? Why do I need one? A trust is an entity you create while you're living that you transfer your ownership of assets into, and that trust holds them during your lifetime. Now, a living trust can be something that you say, well, I'm going to put my house in my trust. I'm going to put it in the, Smith Revocable Living Trust, etc. Why am I doing that? Many people are under the misguided opinion that putting your house, your bank account, your stock, your bond, into a living trust avoids inheritance tax. You named your kids in the living trust to inherit from you. And people will say, well, doesn't that avoid the whole inheritance tax issue? No, it does not. The living trust, that's a revocable living trust, is a vehicle used to put assets in the trust name, but the law looks at it just like you own it. So at your death, yes, there's inheritance tax. There can be income tax. And the other thing is, it may not in any way protect that home if you would need nursing care and you would need to apply for government benefits. Again, people are under the misconception that I put this thing in a living trust, and my house is in there, my bank accounts are in there, and if I get sick and go into a nursing home and need some financial help, well, that's not going to be a problem. That's not going to count against me. And the answer is, you're wrong. It will count against you. A living trust is a way to take certain assets and avoid the probate process. That can be done. And that would trim some cost off at the time of death. But you have to realize, by creating a living trust, you also are going to incur upfront costs. You're going to pay an attorney to prepare that document, and usually that is not just a very inexpensive document. That costs some money. And then you're going to follow it up. Because if you create a living trust to transfer your home, you're going to have to then create a deed and transfer your home. Excuse me. And then you're going to have to record that deed. So there are costs involved. And although it can be said to avoid some probate, again, it's not the be-all and end-all. One other thing, excuse me, about this whole planning and then, the idea of a living trust, or people will talk about gifting. People will come in and say, well, I'm planning. I want to transfer my house to my children. Is that a good idea? And it may be. It may be, but you got to look at all the factors. We got to look at how old are the people? What is their health? Are there income tax implications? Are there inheritance tax implications? What about control? So people say, I'll transfer my house to my son, my daughter, whomever. Well, I don't own it anymore. Maybe my daughter-in-law or my son-in-law doesn't like me. Something happens to my son or daughter, and bingo, my daughter-in-law or my son-in-law wants to throw me out of my own house. That's a problem. When you gift a home, if you gift that home and you die within a year, that value is subject to inheritance tax. So you don't get away from that. You have to be careful with gifting a home, particularly if you're sickly and you would go into a nursing home and you would need Medicaid, you would need benefits from the government. The nursing home issue, we look at all gifting within 5 years of applying for medical assistance. You gift your home, you got to do that in consultation with an attorney. You've got to look at all the issues and decide what's best for you. Now there are ways to, consider to cut down sometimes on inheritance tax, or making things easier for the kids at the time of death. And some people, for instance, will take an investment account they have and they'll make it a payable on death account. TOD or POD, payable on death, transfer on death. And if you can do that, you die, you have an account sitting, that account, upon application by your children, will then pass to your children. Does not avoid inheritance tax. It just makes it a little easier for them to obtain the funds that are in there. I also want to point out, you need to check your beneficiary designations. If you have life insurance, a pension, an IRA, an annuity, see who you have named on those documents as your beneficiary. Many people have named beneficiaries years ago. They have old policies, and they say, well, I think my kids are on there. Well, maybe they are, maybe they aren't. You need to check that. It's important. With life insurance, it's not an inheritance tax issue, tax-free. My advice usually is life insurance should pass to your spouse first, of course, and then to your children, and make sure people are named so that you've made that easy. Same with an IRA or a pension. Make sure the names are on there. It has been my pleasure to talk to you today. If we can be of any help to you, please feel free to contact our firm, Quatrini Law Group, 724-552-2725. Thank you, and have a very good day.
And you've been listening to Dave DeRose of the Quatrini Law Group, with an office on East Main Street in Uniontown and an office in Somerset as well as Greensburg. And you can join them the first and third Monday of each month at 11:25 for Quatrini Law Group here on WMBS. Their phone number is 888-534-6016. Again, 888-534-6016. It is partly sunny and 38 outside of our Davis & Davis Attorneys at Law Studios on this Monday, the 17th of November at 11:54. And we'll close out here with a little bit of America's Best Music before the top of the hour. And let's play this one for you. The Raspberries and Go All the Way.
My love,